The North American Dredging Company of Texas made a contract with Mexico to dredge the port of Salina Cruz. Mexico refused to pay nearly $250,000, a fortune back in the 1920s. The contract included what was called a Calvo clause. The company promised that in the event of a dispute, it would submit to the jurisdiction of the Mexican courts, as though it was a Mexican company. The clause then said, under no conditions shall the intervention of foreign diplomatic agents be permitted in any matter related to this contract. When the dispute emerged, despite that term in the contract, the company sought the intervention of the United States government in the American-Mexican Claims Commission, a body established by treaty between those countries. Mexico claimed that the commission had no jurisdiction because of that section that I've just quoted in the Calvo clause. The commission began by noting that it is certainly possible for two parties in a contract to agree that disputes will be resolved in one or another jurisdiction, that a person might relinquish the rights they have in their own country and instead rely on the rights of a citizen in another country. So there was no problem with the company agreeing to be treated as a Mexican company for the purpose of the contract. The question was whether the jurisdiction of international law could be ousted, or whether, regardless of what was in the contract, a national government could still decide to step in and defend the nation's own rights by taking the case of its national. The tribunal accepted this principle, saying a contracting party cannot deprive the government of his nation of its undoubted right of applying international remedies to violations of international law committed to his damage. Such government frequently has a larger interest in maintaining the principles of international law than in recovering damage for one of its citizens in a particular case, and manifestly such citizen cannot, by contract, tie in this respect the hands of his government. However, they concluded that even if the US government stepped in, the tribunal would still apply the contract, and the contract would disallow the company from relying on the help of the US government. As a result, this particular Calvo clause was effective, and the matter had to be resolved by Mexican domestic law.